for the rights of the persons appearing before its committees. Based on the concurring opinion of Justice Briand, thus, Neri cannot be deprived of his liberty without the due process of law as provided under Article 3, Section 1 of the Bill of Rights. Short of actual denial of liberty, Neri should, as a matter of constitutional right, likewise be protected from the revelation that he appeared in the congressional investigation. All this right should be guaranteed to him without need of distinguishing and first pleading between coercive and punitive contempt. The rules of procedure governing inquiries in aid of legislation, Section 18, Paragraph 2. Such witness may be ordered by the committee to be detained in such place as it may designate under custody of the Sergeant at Arms. This violates the Bill of Rights. No person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws. In the end, Congress exercised a disputing power to arrest within an obligation to navigate the fine line between protecting the integrity of its proceedings and ensuring that the rights of the person appearing before its committees are respected. Be that as it may, it is important to remember that contempt of Congress is always subject to the legal and constitutional limitations, lest we forget the Constitution's mandate to protect the democratic ideals of this nation. In the case at hand, clearly, the goal of the respondents is not to conduct an inquiry in aid of legislation, but instead to fish for any evidence, whether reliable or not, whether truthful or not, for the purpose of persecuting petitioner, and more importantly, for purpose of persecuting him and making him a public mockery of him.
Counsel, is it your position that there's no specific provision which gives the Congress the power to issue or to arrest any person?
There is that explicit written in the Constitution, Your Honor.
Okay. So if there's no specific provision, is there not any other way, or is this power not implied by the fact that they can actually do legislative inquiries?
It provides that it should be in accordance with its duly published rules and procedures. However, the duly published rule of procedure based on Section 18, Paragraph 2, that the committee may detain or may order to detain an individual for contempt. But what I'm saying is that that is not, that it violates the Bill of Rights, the Article 3, Section 1.
So your position is that that specific provision is violative of the bill?
Yes.
Thank you very much, Ms. Apu. Now, to Ms. Apu, Mr. Jestre, you have 2 minutes.
Good morning, ma'am. Good morning, judges. Good morning, Your Honors. So, I'd like to ask, do you agree that an increase in aid of legislation must be based on the legislative intent, or else it will not be pushed through?
Yes.
Yes, I take it that you have read Section 17 and Section 18 of the Rules of Procedure governing increase in aid of legislation, yes? All right, thank you. Now, do you agree that logically, if there is no witness in the aid of legislation, the aid of legislation will not be effective, yes?
It should be constitutional.
Or, okay, thank you. Do you agree that if Pastor Quiboloy will deliberately fail to be absent or comply with the required attendance by the Senate, then there will be no aid of legislation?
The Senate resolution is very accusatory.
Counsel, I'm going to ask questions, you are going to answer yes or no. Thank you. All right. So, do you agree that the attendance of Pastor Quiboloy is necessary for the aid of legislation? Yes. Yes or no?
No.
Okay. Do you agree, or do you affirm that the Senate has the authority to ask for the witnesses' attendance for aid of legislation?
I'm sorry. Again.
Do you agree that the Senate has the authority to ask for a witness' attendance for aid of legislation?
Yes, but.
All right, thank you. Do you agree that the decision to withdraw the contempt citation and arrest order will weaken the Senate's mandate to conduct increase in aid of legislation? Yes or no?
I'm sorry.
If so, do you agree that if we allow, under this pretext of violation of due process and the right of self-incrimination as what we have presented, high government officials will allow powerful individuals to avoid facing Senate hearings? Yes.
No.
Have you read the recent decision of the Supreme Court about the arrest warrant of Apollo Quiboloy, saying that the arrest warrant still stands?
Yes.
Okay, I take it that you agree that the Senate arrest warrant is different to that contemplated of an arrest warrant from the judiciary? Yes. Okay. Now, should the Senate then just wait until Apollo Quiboloy appears before?
Sige, you give your answer.
Well, in either
Yes or no?
No.
Thank you. Thank you. So that is the interpretation. Now, Mr. Jestre to argue why it's not necessary to declare the arrest warrant of the Senate unconstitutional. You have 4 minutes.
Your Honors, Counsel Whitburn. As the first speaker of the negative side, I will speak on the necessity to affirm the constitutionality of the Senate's arrest warrant issued against Apollo Quiboloy, and I will be rebutting very briefly on the flaws that the speaker of the affirmative side had laid out. They specifically had mischaracterized what the necessity, the non-necessity of the Senate's arrest warrant. They have failed to do that, Your Honors. Also, to begin with, let us talk about the core topic of this proposition that the Senate arrest warrant is unconstitutional. Let us define what is constitutional then. Unconstitutional it means that an act or a law is not in accordance with our Constitution, the fundamental law of the land. Also, in regards to the issue of aid of legislation, we respectfully admit to the notion that the art of questioning as well as the questions during the legislative inquiries are perceived to be similar to that of a grandstanding committed by a politician. That is why we propose in our model, in consonance with the Constitution, we will strengthen the ability of a witness to invoke the right against self-incrimination. We will strengthen the judicial oversight, which will be discussed by my groupmates later. Here are the reasons why the affirmative side strongly affirms the constitutionality of the Senate premise on the grounds that it is of utmost necessity. Firstly, the warrant of arrest is only executed in order to compel the attendance of a witness who is vital in the aid of legislation. I take it that you know that Apollo Quiboloy is very vital in the aid of legislation. Without him, there will be no aid of legislation that will be realized. In a 2023 ruling of the Supreme Court of the Farmley case, the Supreme Court held that an arrest is necessary to carry out the coercive aspect of process of compelling attendance, testimony, and production of documents relevant and material to the legislative inquiry. And I take it that Apollo Quiboloy's attendance is very much important and significant in order for the aid of inquiry or legislative inquiry will be realized. Also, moreover,
if Apollo Quiboloy will join the Senate hearing either voluntarily or through your arrest warrant, if Apollo Quiboloy invokes rights of incrimination, can you get answers from him in the legislation?
that is why in our model, Your Honor, we will try to strengthen the art of questioning that can be questioned by the Senate, Your Honor, because I think that invoking the right against self-incrimination is very vital, and in our model, we are not going to violate that. We will strengthen that by actually trying to ask questions that may not be self-incriminating, but also important to the purpose of aid of legislation.
Can Pastor Quiboloy refuse to answer?
Yes.
Quiboloy will go to the Senate.
Yes, Your Honor, so long as the questions are self-incriminating. But if the questions are not self-incriminating, that's why in our model we will try to strengthen again the ways that we're going to.
Counsel, but there are already arrest warrants issued by the court, and so as Quiboloy is saying, I'll just go to court and answer. Why do you need to drag me here in the Senate to answer questions which will be asked later on in the court? So why not just answer in courts?
The reason for that one, attorney, because the arrest warrants contemplated by the law in the Senate is different to that of the Senate arrest warrant contemplated in the judiciary, Your Honor. To continue, secondly, it does not enable a witness to evade the law. Logically speaking, if we are to subscribe to the notion that such arrest warrant is unconstitutional, wouldn't that be a sign for people who are important in the aid of legislation to just say no to such a request to be present before the Senate? And if it is constitutional, which it is, it gives teeth to the law, which is important for people in order to follow them. I think that you would agree with me that there are some laws that require coercive aspect in order for people to follow it, such as the seatbelt use of 1999, which mandates the people to use their seatbelt or else they will be given sanctions. Also, by virtue of the Senate arrest warrant, it dissuades resource persons to avoid the requirement of being present. Also, lastly, it would be, I will talk about the very briefly on the beneficiality.
Okay, one last question. So there are simultaneous warrants issued. And so if the Senate will give the warrant and the police are also there to serve the court's warrant, so who will Quiboloy go with? Like, will Quiboloy go to the Senate or to the police station, the courts, or how do we go about that? If the warrants will be served
In the case of, thank you, Your Honor. In the case of the farming owned versus the Senate of the Philippines, Your Honor, it was said that the court held that regardless of the pending cases of the court, Your Honor, the resource person can still go to the Senate in order to answer the questions, which is important and vital in the aid of legislation, Your Honor.
Thank you very much, Mr. Jestre. Now, Ms. Aki, you have 2 minutes to interpret.
Council, by any chance, but I would assume that you have read Senate Resolution 884 as well. How about Senate Resolution 797?
Yes. And so what's the relevance, Council?
Let me proceed.
Okay, thank you.
Senate Resolution 797 is about the same law being reviewed in Resolution 884. Is this not a duplication, hence wasting the precious time of the Senate?
What's the relevance, Council?
They're both about the topic with Mr. Quiboloy. And is it not the same law reviewed already? And does our Congress or Senate conduct review of our laws every time there are reports regarding them? Or is this just an act of, I would have, act of our respectable senators? And also, is it not, nothing is new under the sun? Incidents of this nature have been reported, published, not only in the Philippines, but all over the world. My concern is, why now and again is this undertaking an abuse of power of the Congress?
No, I think that you could have you have heard what I've said in my
Yes or
in
no?
practice. Yes.
As per rules of procedure governing inquiries in aid of legislation, Section 18, Paragraph 2, such witness may be ordered by the committee to be detained. Is the detention without procedural due process constitutional?
There is
Yes or no?
yes, there's procedural.
Is the Congress power in aid of legislation superior over the constitutional rights
No.
of the citizens? Does the Supreme Court upholding such power at the expense of the individuals constitutional?
Your Honors, may I request that
Yes
Council
or no?
speak properly? Thank you so that I can
Thank
hear.
you very much. So that is the necessity of the proposition. Now we go to the beneficiality. Mr. Reyes. Reyes. So argue why it's beneficial to declare the arrest warrant issued by the Senate as unconstitutional. You have 4 minutes.
Good day, everyone. As we continue our discussion on why the Senate arrest warrant against Apollo Quiboloy is unconstitutional, I will focus on the benefits of recognizing and rectifying this constitutional violation. I stand before you today to argue that the Senate's warrant of arrest against Quiboloy is unconstitutional due to the non-observance of due process, the violation of his right against self-determination, and the misapplication of the rule regarding inquiries in aid of legislation. Allow me to elucidate these points and demonstrate why this action sets a dangerous precedent and why this is declared unconstitutional will be beneficial to the rule of law in our country. First and foremost, the principle of procedural due process is a cornerstone of the legal system. Procedural due process ensures that any action that affects the rights of individuals must follow a fair and established procedure. A process that ensures any actions that affects the rights of individuals must follow a fair and established procedure.
Why is there a violation of the process of the right against self-determination? And the purpose of the arrest warrant is to compel Quiboloy to attend the hearing and not, he's not being charged of any case, he's not going to jail, he's just required to attend the said hearing. So why is there a violation of the right to due process and right against self-determination when he can actually refuse to testify if it's incriminatory?
Your Honor, in the case of Mary, the Supreme Court held that the Senate is not a The Supreme Court held that the Senate is not a trial agency. Therefore, it shouldn't be asking those questions. In its resolution number 884, it specifically said that considering that the crimes were committed within the territorial jurisdiction of the Philippines, Quiboloy has been already a judge. And in its position, the Senate also already stepped into the role of the judiciary. To continue, the principle of conducting inquiries in aid of legislation must be properly.
Counsel, are you saying that legislative inquiries are the same as trying a person for a crime or an offense?
No, Your Honor, but in the case of Quiboloy, it seems it's going that way.
How is it so?
Let me go back to Senate Resolution 884, that the purpose of the resolution, whereas considering that the crimes were committed within the territorial jurisdiction, isn't it that crimes should only be tried in the courts and not in the Senate? Why were they talking about crimes in the first place? So,
Are you
first,
saying then, Mr. Speaker, that crimes are off limits in legislative inquiries?
yes,
What's your basis?
the Senate in aid of legislation should be, as the term connotes, in aid of legislation.
And what if that in aid of legislation, you have to necessarily talk about the crimes committed?
Then we will have the court to decide on that. In conclusion, the Senate's warrant of arrest against Mr. Quiboloy is a clear violation of his constitutional rights. It disregards due process, infringes upon his right against self-incrimination, and misapplies the rule of legislative inquiry. Upholding the Constitution is paramount to maintaining justice.
Thank you very much, Mr. Therese. Now, Mr. Clark, you have 2 minutes.
Council, Your Honor, good morning. Question, do you believe that in aid of legislation is beneficial not just for the government but for the Filipino people as well? Yes or no? Do you agree that to properly execute in aid of legislation in cases such as rape, in cases of charismatic movements or consent in rape or labor issues in these charismatic movements, a pastor, in this case Apollo Quiboloy, is required and should attend the Senate hearing in aid of legislation?
Yes, but with reservations.
Would you agree that self-incrimination, as you brought up earlier, only starts during the actual trial and the questioning in incriminatory questions that are asked in the hearing?
No, but with reservations.
If so, okay, you said no, would you agree that Pastor Apollo Quiboloy should attend the Senate hearing first before he can decline to answer questions invoking the right to self-incrimination?
I disagreed earlier.
If so, then of course, if that is your point. Now, considering that if Apollo Quiboloy should go to the Senate first before trying to invoke self-incrimination, then there's no danger for Apollo Quiboloy to appear since he's just invited and he is not accused of a crime and he's not tried for an actual crime because the Senate hearing is just for an aid of legislation. Do you agree? Yes or no?
No.
Do you agree that the due process is violated only when the Senate is not following the threefold limitation of the legislative inquiry? Do you know the threefold limitation?
Yes.
Okay. Now, you mentioned earlier due process. If you have heard, I believe you have heard the news recently about this issue.
Yes, with reservations.
Robert Padilla, he was against the arrest warrant. Therefore, he was given ample time to gather 8 signatures, but failed to do so. Isn't that due process? Yes or no?
No.
That would be all, Your Honor.
Thank you very much. Now we move on to why it's not beneficial to declare the arrest warrant unconstitutional. Mr. Clark, in 4 minutes.
Your Honor, councils, ladies and gentlemen, good morning. As the second speaker of the negative side, I stand before you to reaffirm our stand on the constitutionality of the arrest warrant of Apollo Quiboloy. Your Honor, this arrest warrant is indeed constitutional, as enshrined in Article 6, Section 21 of our Constitution, and is furthermore supported by Section 17 and Section 18 on the Senate Rules and Procedures in aid of legislation. And even if there are certain statutes that would contradict this fact, we would still be in favor of its constitutionality, invoking the supremacy of the Constitution. And this constitutionality of this arrest of Quiboloy will benefit not just the legislation, but the Filipino people in general, for public welfare and safety. First, had Apollo Quiboloy appeared during the Senate legislative inquiry, the Senate, this would have helped the legislative department in enacting new laws pertaining to prevalent issues in his circle. For instance, as what I mentioned earlier, consent in rape or sexual assault in religious sectors or charismatic groups, or even labor issues in these sectors, which is very common in the Philippines, since we all know that we have a lot of charismatic groups here in the Philippines. Second, his appearance in Senate will show the public that the legislative department has the power and strong will and is serious in its task in creating laws. That even a high-profile personality followed by thousands, if not millions, Apollo Quiboloy, who is even linked to many politicians and even the former president, cannot deny the Senate of its power to subpoena and demand appearance of resource persons in inquiry in aid of legislation. And lastly, his arrest being constitutional affirms that the provisions of the Constitution reign supreme. And even the Supreme Court, in cases, in the Formally case, and even in the case of Romero et al. Versus Estrada in the Senate Committee on Labor and Employment, as mentioned earlier, that it might be incriminating, and of course, as mentioned by our judges earlier, that he has a pending trial, a pending criminal case. But the Supreme Court in this case affirmed that the pendency of a criminal or an administrative case does not bar the Senate in inviting persons in aid of legislation. And even on the most recent decision of the Supreme Court, they affirmed the legality of the warrant of arrest. And this case is not peculiar, Your Honor. Just recently, the same Senator Therese invited Senor Aguila. In the same picture that he is a sectoral leader, a charismatic group leader in Surigao. We never heard about complaints of unconstitutionality or even grievances. And now, if we will entertain the idea that Apollo Quiboloy's arrest is unconstitutional, it would take the trust of the Filipino people in our legislative system. And it's an even clear violation of the Equal Protection Clause. Questions like, why is Quiboloy exempted? Is it because he's known to many politicians, or is it because he's an ally of the previous administrations? Among others will rise. And that will furthermore paint a bad image of politics in the Philippines. Your Honor, we'd like to remind everyone in this room that the main purpose of the law and statutes of our land is for the common good of the Filipino people.
Counsel, does this not violate the principle of sub judice? A case is already pending, and if you invite people to attend the Senate hearings, then it will be, the issue there will be the same in court, and under that principle, it must be left.
No, Your Honor, because once again, we would like to make it clear that the invitation in court is criminal in nature, while in Senate, it is in aid of legislation. Therefore, there are no criminal accusations against him. In fact, he can even invoke his right against self-incrimination.
Another question, is it your position that just because Senior Aguila did not complain, Quiboloy can also complain about the violation of his constitutional rights just because Aguila did not invoke it?
No, Your Honor. Our point is that since Aguila did not invoke it, why would we grant this to Quiboloy? It should be in the same. It should be in the same circle since they have the same standing. They are leader of.
So, are you saying that because someone did not invoke it, it was not possessed?
No, it doesn't necessarily mean, Your Honor. What we're trying to say is that why would they consider this issue now, where in fact in similar cases it was never an issue to begin with. Just because it's Quiboloy, we will consider that fact, and it will paint a bad image on the legislative
Okay,
department.
if I'm subject of the Senate inquiry, then I'll invoke that. Then, can I not invoke it? Like, violation of my constitutional rights? The issue is not about who is being asked to attend, but are arrest warrants issued by the Senate constitutional or not? Regardless of the person.
Yes, it can be invoked, Your Honor, but the question is it constitutional? So our stand is, it is constitutional, even if it invokes that right. That will bill. Thank you.
Thank you very much. Now we give Mr. Therese 2 minutes to interpret.
I take it that you've read resolution number 884.
Yes.
And you've read Senate resolution number 797, as what you mentioned earlier.
Yes, and what is the relevance of it in this case?
You just mentioned earlier that 797 is about Senior Aguila, right?
Okay.
Okay. Did you see the difference between the two Senate resolutions?
No.
No, you didn't. Okay. Specifically, 7884 specifically mentions considering that the crimes were committed within the territorial jurisdiction of the Philippines, and considering that the crimes are taking place even at present, as Quiboloy remains free to run the operations of KOJC, it is imperative that an investigation be undertaken with dispatch.
Isn't it that at that point the Senate already tried to judge Quiboloy that he is guilty or committed some crimes?
No. Senate hearing is not a criminal hearing. There's no judgment at all.
Have you heard of the Senate? Have you heard of Senator Robin Padilla's pronouncement on Quiboloy regarding his?
Yes.
Okay. Now, did you know that Quiboloy was a previous supporter of President Duterte?
Yes.
And isn't that that's something that could have ring a bell? Why is he persecuted with this?
No.
No further questions, Your Honor.
Thank you very much. So that is the beneficiality aspect of the proposition. We go to the final speakers, practicability, arguing for the proposition, why we can declare the arrest warrant unconstitutional. Ms. Diosa, you have 4 minutes.
Your Honors, ladies and gentlemen, as we conclude our argument, I will discuss the practicability of viewing the Senate arrest warrant against Apollo Quiboloy unconstitutional. The unconstitutionality is grounded in both legal precedent and the consistent application of the legislative procedures. So let us examine the cases of Diogenes Judicial and Marlo and Mark Louis Mendoza. Judicial is a physician from the Philippines who was indicted in the District of Guam in 2004 for engaging in a fraud scheme against the TRICARE medical insurance program for overseas veterans. Similarly, Marlo Mendoza was indicted for illegally shipping firearms parts and ammunition to the Philippines. And her son, Mark Louis Mendoza, was charged in an 8-count indictment with conspiracy, the unlawful export of ammunition, smuggling, and money laundering. The arrest warrants were issued on December 2015 in the Central District of California. Despite the gravity of these offenses and their international implications, the Senate did not conduct hearings in aid of legislation. Instead, these cases were handled through the judiciary, respecting the separation of powers and ensuring due process. So the discrepancy in handling similar offenses were even more severe. Yes,
Same question as with the negative. Are you saying that because the Senate did not exercise its power to inquire at a previous time, are you saying that they cannot invoke it now just because
no.
they did not do it?
Yeah, no, Your Honor. What I'm saying is that our contention is that the Senate has no basis in selecting what are the issues or the concerns that can be conducted.
Besides, if it's not the Senate.
There's no like specific process or procedures implemented, Your Honor. That's what we are trying to contend. So to continue. Okay, so resolution number 884 makes several serious allegations against Apollo Quiboloy and the Kingdom of Jesus Christ, presenting them as established facts rather than unproven accusations. This language could indicate a prejudgment which might undermine the neutrality expected in a legislative inquiry. If we allow the Senate to overstep its bounds in Quiboloy's case, it sets a dangerous precedent. It opens the door for future misuse of legislative power where political motivations might overshadow the objectives pursuit of justice. So if the Senate believes Quiboloy should be compelled to testify, then it should seek the intervention of the courts, which are equipped to handle. Yes.
Are you aware of the Senate hearings about Janet Napoles?
Yeah.
Do you remember the time when Napoles was invited to hearings and wearing that orange uniform? Do you remember that?
She always invoked her right to self-determination.
Yeah, so, but still, she attended. So, are you saying that we can do it to Napoles and not to
Oh, okay, yeah. That's why we have this, the Senate issued a resolution 797 regarding the group of J. Renz Kilario, or commonly known as Senior Aguila. So The resolution is about to conduct an investigation into the allegations of systematic rape, sexual abuse, trafficking, forced labor, forced marriage of children in the context of cult-like activities among the members of SBSI. So I think they have the same issue, Your Honor. So that's why I think it's already redundant for the Senate to conduct the same.
So you're saying that you're against the purpose of the inquiry, but not the power of the Senate?
Yes, Mr. Okay, so to continue, again, if the Senate believes Quiboloy should be compelled to testify, it should seek intervention of the courts which are equipped to handle such matters impartially and according to the rule of law. Declaring the Senate...
Speaker,
Yes.
can you make it very clear to this court, what are the laws that will be violated or breached if this court does not hold the proposition, or if we do not deem it unconstitutional?
Your Honor, I'll go back to Article 3, Section 1, which is about the Bill of Rights. There is no, no person shall be deprived of life, liberty, and property without due process of law, nor shall any person be denied the equal protection of rights.
You will not
Yes.
deprive of his liberty, you will just attend the hearing.
But I think they are compelling, the Senate is compelling Quiboloy to attend the hearing, but it is his, I think, constitutional right to not join or to not attend the hearing.
Last question, Speaker. Wasn't there already a previous case discussing the legislature's power, specifically in the case of Vermont?
Yes, Your Honor, but in that case, I think it's more on the. But what I'm saying, Your Honor, is that in this case, there's already an investigation conducted last September 2023. That's what I mentioned earlier about the Senate resolution about Senior Aguila. So that's why I think it's redundant already for the Senate to conduct the same investigation.
Thank you very much, Ms. Mendoza. Now, for our last Ms. Sayson, you have 2 minutes to interpret.
Good morning, Council. My first question is, do you agree that the purpose of a legislative inquiry is to gather evidence for the creation or amendment of legislation?
I agree.
Okay. Do you agree that the presence of the accused in this legislative inquiry would speed up the promulgation of new laws for its
It
amendments?
depends.
Do you agree that the continuous refusal of the accused to attend these inquiries has been causing delays in these proceedings?
No.
Do you agree that it is our obligation as citizens to abide by the laws of the land and provide what is necessary to aid its progress? Okay. Do you agree that he would not be in this predicament had he simply performed an obligation that every citizen of this country is bound to perform?
No.
Do you agree that legislative inquiries is not judicial in nature?
It's not usually judicial.
So the answer is no. Yes. No, so judicial in nature. So do you agree that there is no determination of being guilty or not in such proceedings in the
It
Senate?
depends upon the questions.
Okay, now do you agree on justice and fairness?
Yes, of course.
So do you agree on the premise that the arrest warrant issued of the accused is unconstitutional as a clear violation of his rights?
If he has due process, there's no due process.
There is no due process. Okay, so aren't every Filipino citizen be exempted from any and all legislative inquiries?
I think. What's the question?
Okay, so isn't it a blatant disregard to the investigative power of the Senate if the arrest warrant against Apollo Quiboloy would be declared unconstitutional? Would it be a blatant disregard to the investigative power of the Senate if the arrest warrant would be declared as unconstitutional? Blatant disregard.
No.
No. And last one, do you agree that it takes a very long period of time in order for the amendments? Okay.
Thank you very much. Now we are on to our last speaker, and Ms. Sayson, please argue why it's not practicable to declare the arrest warrant unconstitutional.
Your Honors, Councils, ladies and gentlemen, good morning. Our team advocates to enforce the constitutionality of the Senate's arrest warrant issued against Apollo Quiboloy, and we believe that it is not just practicable but is indeed lawful and essential to move forward on the main purpose of this proposition, which is inquiries in aid of legislation. However, before I present my arguments, I would just like to rebut some of the flawed arguments of the affirmative side. So first, the third speaker of the affirmative side mentioned of some inconsistencies in the legislature's conduct of inquiries in aid of legislation. However, there have been cases, very effective cases, particularly compelling the attendance and obtaining critical testimonies during the legislative inquiries. One of which is during the case of Janet Lynn Napoles in 2013, wherein Napoles was subpoenaed and subsequently arrested by the Senate to ensure her testimony. Her appearance provided crucial insights into the corruption scheme, demonstrating the effectiveness of the Senate's powers in uncovering significant issues. In addition, the Senate also has the discretion on how are they going to conduct their inquiries in aid of legislation. They have the discretion over how they're going to deal with an issue. And also, it is not a sub judice, it does not violate sub judice because again, the purpose only here is aid of legislation, which is not to convict, which is not to detain, but only to ask questions in aid of legislation. Now, I would like to present why the Senate arrest against Apollo Quiboloy is constitutional and is practicable. So now, firstly, aid of legislation has been practiced by the Congress as a power vested in it by the Constitution for the longest time. And since then, there were no questions on the constitutionality of such provisions. So now, our bench posits the question, what makes this case so different to the other cases of legislative inquiries? So now, the power of the Congress is enshrined in Section 17 of the Rules of Procedure governing inquiries in aid of legislation. It provides that the committee shall have the powers of an investigating committee, including the power to summon witnesses and take their testimony, to issue subpoena and subpoena ducis tecum, signed by its chairman or on his absence by the acting chairman and approved by the president. Also, jurisprudence also provides that the Congress is not precluded from causing the appearance of a resource person, as long as the testimony. Yes.
Is there any provision there or any word arrest there? Or it's just subpoena?
There is no word arrest.
Is it the same? Subpoena and arrest?
No, Your Honor. So I believe subpoena is a document which is issued in order to request the attendance of the
So
accused.
why not just issue that? Because that's what is provided there. It doesn't say arrest. Under the Constitution, you can only arrest a person when there's probable cause, and it can be issued only by the court. So why are you saying now that the Senate will do it? But in fact, under the provision that we read, it just says that they can subpoena to compel attendance. So why do we need to arrest Pastor Quiboloy?
Section 18 of the same rules of procedure specifies here that
Just issue a subpoena.
Section 18. The word can only be here, attorney, it's
Yeah, go ahead.
it's stated here that they can compel by way of an arrest the appearance of Apollo Quiboloy, attorney.
Can you read the provision? Can you read the provision?
It's actually jurisprudence, attorney, Ong versus Senate of the Philippines. The Congress, any House of Congress or its committees may compel by way of an arrest his or her appearance in the inquiry proceedings. Necessarily, compelled testimony connotes truthful declaration by a resource person subject of the legislative inquiry.
Is it okay? Thank you very much, Ms. Sayson. Now we're on to our last speaker today. Ms. Mendoza, you have 2 minutes to
So Council, I take it that you're familiar with Senor Aguila. He is the president of Socorro Balenihan Services Group.
Yes.
Are you aware, Council, that in the Senate Resolution 797, SBSI has indicators of a religious cult with Senor Aguila as its messiah and leader?
Yes.
And again, as what I've discussed earlier, are you aware that resolution number 797 is about systematic rape, sexual abuse, trafficking, forced labor, forced marriage of children in the context of cult-like activities among members of SBSI?
Yes.
And are you familiar with Senate Resolution number 884?
I'm really not sure. What is the relevance of your
They
question?
have the same subject, am I correct, Council?
Yes, and
So, is the agenda in resolution number 797 not similar to Senate Resolution number 884?
I'm really not sure, Council, and then
So is there no redundancy on the part of the Senate to conduct an inquiry based on similar issues? Council? Yes or no? Is there no redundancy on the part of the Senate to conduct an inquiry based on similar issues?
no.
Then, Council, do you think that the Senate's actions against Quiboloy could be driven by other motives, such as political gain or public
No.
spectacle, perhaps? So don't you think that the inconsistency in handling Quiboloy's case compared to Judicial Mendoza's case suggests that the Senate's action may not be purely legislative, but influenced by external
No.
factors? Isn't it true that an inquiry in aid of legislation should be neutral and focus on fact-finding rather than prosecutorial in
Yes.
nature? So, Council, are you aware that Resolution number 884 contains several allegations against Apollo Quiboloy and the Kingdom of Jesus Christ, such as brainwashing, psychological manipulation, and sexual exploitation?
Yes.
Okay, then, Council, does this not indicate prejudgment and bias?
No.
Thank you.
Thank you very much. So that's match for Quiboloy's arrest, whether it's constitutional or not. Now we're down to our last match. Before we continue though,